Hello, good evening, and welcome to the 10th Better AI Meetup. Yes, we are in double digits now, and we'll be, I'm quite sure, in triple digits as well. It will just take a little bit more time. Maybe I'll be replaced by a very large language model. We will see, because we don't know, but that's the purpose of the Better AI Meetups, to know something before anyone else. So, as always, I welcome you on behalf of Kinit and Innovatrix, and this time Hopero as well. And before we start talking about AI Act, it is my pleasure to welcome Maria Bielikova, CEO of Kinit, to remind you that you too, just like us in Innovatrix, could take part in AI awards, which are held this year for the first time. So, Maria.
Thank you. Hello, everyone. Can you put the slide here? Yeah, perfect. Actually, it was already announced, but I'm happy to announce it once more, that you still all have one more week for submitting your product, your project, or whatever you do in AI Awards, Trustworthy AI. Actually, we already have pretty nice number of applications, and I'm so happy to announce that the result will be announced on probably the best business fest, which will be at the end of May, organized by Forbes. So we will not just evaluate your products, but not what the products do, but their trustworthiness. So where we are in this way, with your product, with Slovakia, and that I'm really happy that we have a pretty number of submissions, that it seems like quite a lot of companies are considering this, and this is especially important for today's meetup, as the topic of today's meetup is really trustworthiness, is AI Act. But this is something broader. We want to develop applications that are trustworthy, and we will at this time not evaluate what is inside, why you do this application, whether the technical solution is the best, but what is your thinking in this way. So I would like to point you to this AI Awards SK. You have one more week, so we are very much looking for your applications. We will not announce just the laureate of this award, but more companies, because our primary goal is to promote AI, to promote companies to do trustworthy AI. So you all will be considered by our media partner as well, and by us. So thank you very much.
Thank you so much, Maria. We're very glad to be a part of this to be a part of these awards from the very beginning. So I hope you will all join in as well. So as I mentioned, we are on 10th Better AI Meetup already, and I'm so glad we have basically a packed room, because when we started, at least the first two meetups, it was just me and the guys with the cameras, an empty room because it was COVID. So this is just so much better to have live people. So thank you all for coming. In the intervening few years that the Better AI Meetup was happening, we've been talking about all kinds of AI-related stuff. You may remember, like large language models, generative AI, AI in medicine, federated learning. We even been to Brno talking about voice AI and voice. So much has really happened in the past few years in this field. So it is only logical that the very next step is, of course, regulation. So now we don't want to scare you, but AI Act will, of course, be a huge deal. And what we want you to go home with today is to have a good idea of how it will impact your business, your research, and what can you do to actually be a part of trustworthy AI, as Maria just mentioned. And symbolically, although the AI Act has not yet been approved by the Parliament, today is the day when a European AI office is officially launched in Brussels. So they have been very kind to wait for this Better AI Meetup to actually start. So thank you to Brussels if you're watching us. And yeah, this only means that AI Act is really happening after 3 years of negotiations. Today, my guests will be Matúš Mesarčík from Kinit, who will give you a very good overview of what led to the AI Act and what are its main components. And we will also welcome Juraj Čorba from the Ministry of Investments, Regional Development and Informatization for an interview. Now, Juraj was one of the people that was actually in Brussels from Slovakia negotiating AI Act on the country's behalf, so he has lots of experience. Don't forget that you can ask questions via Slido during any time, and we will answer them after Matúš's presentation and after an interview with Juraj, and we will try to answer all of them. I have already been told we already have some questions, so I know that this topic is very important for many of you. Also, I think that we officially had a record number of people wanting to participate in this meetup. So, AI is just very big. And why is it so? Matúš will give you a very good overview. So, Matúš, please welcome.
Okay, thank you very much for the invitation. I'm really happy that I can share a general overview of how AI Act will work and what it means for you. Okay, perfect. So the name of my presentation is Translating Principles of Trustworthy AI to Legal Compliance with the AI Act. And maybe, as you can also see from the name of the presentation, when you approach AI, it's not good if you approach it only from the computer science or technical point of view, because AI bears not only some kind of technical risks or some kind of technical issues, but it also bears with it very broad societal, legal, and ethical risks. And this is something what we realized in Kinit, and that's why we have a specialized team that is dealing, that is called Ethics and Human Values in Technology, and we are actually dealing with societal and ethical impacts of intelligent technologies. My name is Matúš Mesarčík. I'm really delighted to be part of this team. Being a lawyer, my main role and focus is on AI regulation and digital governance and related research, but we also very broadly focus on ethics, and not only in a way that we are like thinking of how AI should behave or what should it do and what shouldn't do, but we are also putting ethics into practice. We have a very specific methodology and process conducting ethic-based assessments when we are providing to firms, and we are showing like the broader ethical and societal risk that the AI system might bear. And not only that, we do not stop there. We are also showing them how can they mitigate or to implement some mitigation measures when we identify some risks. I will show you something out of it at the end of the presentation, so you to know. So I will start with how we get here, how we get to the AI Act, and what lead us to this moment. And I would like to also bring your attention to the fact that the AI Act is not the only piece of digital legislation related to the development or use of AI. So you would have maybe a bigger picture there. And I will focus on requirements of the AI Act from the general point of view. And I will then focus on two specific topics. So you would have like a better view on it, and I would focus on general purpose AI models in the former versions of the AI Act called foundation models, and I will focus on how some specific principles of trustworthy AI are translated into the AI Act. So let's start with the road to the AI Act. And actually, the road is quite long, and I think it started in 2019 when a high-level expert group on the EU level introduced ethics guidelines for trustworthy AI. it's a very important step because these ethics guidelines for trustworthy AI basically said that when you want to achieve trustworthy AI, it needs to be lawful, therefore it needs to be compliant with legal requirements. It needs to be robust, but it also needs to adhere to the ethical norms. So legal compliance is somewhere at the bottom of this sand cone, and ethics is on the top. That means that if you want to tackle the broader scale of the risks, legal compliance is not always the suitable choice or will not tackle everything, but you need to focus also on the broader layers of the risks. In 2022, bearing in mind also this, the European Commission published white paper on AI, and they basically paved the way for further documents and for further legislation that comes into place now. One of the aims was to develop a legal framework on AI that basically at the time did not exist in the European Union. And finally, in 2021, the European Commission published the original proposal for the regulation of the artificial intelligence, or commonly known the AI Act. So as you can see, we are now in the 2024, and there has been a really long journey there. After the original proposal from the Commission were published, we also in KINIT pointed out some things that were not maybe good according to us, or we see some deficiencies in the original proposal. You can find our stance on that on our website. After a year, the Council published its general approach to the AI Act. After a year, finally, the European Parliament adopted its position. So at the end of the 2023, we have like the 3 versions of the AI Act. And these 3 bodies then entered the trialogue, and finally, at the end of the 2023, they reached the political agreement on how this text should look like. It's maybe interesting to say that general purpose AI models or foundation models were not tackled in the original proposal from the Commission, and somewhere over here it spurs a lot of discussion because that was the time when ChatGPT was introduced to the public. So that's when the legislator also found out, well, that might be an issue. So they were trying to accommodate this in the AI Act. Well, and today, finally, after 1,037 days until today, we have a final compromise text that, as you can see, is pretty long. It's not really an easy piece of legislation. And we finally have it. There was a vote in the European Parliament committees last week. And maybe then my colleague Juraj will tell you more about how these negotiations are going in the next months. But we expect that the European Parliament will formally adopt the AI Act somewhere at the beginning of April. And after the endorsement from the Council and the Commission, there we will have finally the final wording of the AI Act. It's expected that it will be public in the official journal of the EU somewhere in the April, May, or June 2024. And this is a very important point because from that date, we can talk about when AI Act will come into force. It will come into force fully in 2026, so basically 2 years from there, but some provisions will come into force earlier. The first thing is that practices that will be prohibited in the EU will be prohibited 6 months after entry into force, so 6 months after it's published in the official journal of the EU. And rules for general purpose AI models will come into force 12 months after the entry from the force. So so it might be a little bit complicated, but it is usually complicated when it's such a complex piece of legislation. After AI Act will be applicable in the full, it doesn't mean that it ends here, because there are specific provisions that are saying that general purpose AI models that are already on the market, so ChatGPT, Gemini, and so on, they will have to comply with the legislation after 36 months from here. So even there is a system that is already on the market, it doesn't mean that it won't be regulated by the AI Act. This is something that was added in the final stages of the negotiation process. And if we talk about high-risk AI systems that are on the market right now, they will have to comply with the rules if they undergo a significant change. Well, there is a legal definition of what is significant change in the AI Act, but as I see the documents produced by the EU bodies, they expect that basically every AI system will undergo a significant change at some point. So far to the compliance with this. And like I said, I will talk mainly about AI Act. This is like this small piece of puzzle here. But to give you like a broader overview that AI Act is not the beginning, not the end, every square that you see on the slide represents one piece of legislation, that it's basically regulating the digital space. There are legislation governing copyright, intellectual property rights, data and privacy, trust and safety, competition, finance, media, and so on. And for example, when we talk about the development of the AI systems, we talk about also, we have to talk about data and privacy. We also have to talk about personal data. We also have to talk about respecting the copyright policies, because you usually train models on a lot of pictures scraped from the internet, right? So that's when the copyright plays a very important role. When we talk about the recommending system on the social media, we have to talk about the Digital Services Act. When we talk about respecting human rights and sustainability issues, we talk about very specific legislation that is in the pipeline and will be also applicable to the firms developing AI, that is dealing with the environmental issues and respecting human rights, and so on and so on. So this is just for you to remember that AI Act is not the only thing you have to focus on right now. But as it's maybe most up-to-date thing here, we will talk about it during this presentation. So I'll focus on the AI Act, and like I said, I will give you a general overview. So first thing that might be of the interest is that what actually will be banned in the AI Act. And this is the final list of the banned practices. Some things were added later in the legislative process, some things were there in the beginning. The biggest hurdle and the biggest discussions were, of course, about real-time facial recognition softwares and so on. This is basically something that is banned for law enforcement, but there are exceptions where it can be used. And basically, if it's not this case and if it's not banned, it's high risk. But I will get that. I will get there very soon. The other things that are banned are, for example, social scoring for public and also for private purposes. So not only something that you may have heard that is going on in some Asian countries, where they have like credit scoring system that's assigning you a credit based on your behavior. And if you have a positive credit score, you can use some public amenities like faster trains, so you can get your children to better universities. If you had low rate, if you have a low rate, you cannot do any of those what I just mentioned. So this is something that will be banned here. And there is also a later addition to the banned practices that is a reflection of some attention from the media that actually happened, and it will be banned to do untargeted scraping of internet or CCTV for facial images to build or expand databases. Very up-to-date thing, at least for training AI models. And there are some other bans. But the AI Act is mainly focused on high-risk AI systems. So over here, it's not that much focused on systems that have limited or minimal risks. There are only some specific transparency obligations and encouragement to draft codes of conduct for these companies that are developing and using limited risk or minimal risk AI system. But the main focus of the Act is on high risk systems. When do you know when some system is high risk? Well, if it has adverse impact on people's safety or health or fundamental rights. But AI Act is, of course, more precise on this. If you want to know if your AI system is or should be considered high risk, there are basically two sources you should look at. First source is a list of legislation indexed in the Annex 2 of the AI Act, and it basically references around 20 regulations or directives. And if you find that your AI system or a product is in the scope of this or one of those regulations, you should also conform with the AI Act, because you should also undergo the conformity assessment. So I'll give you an example. For example, you can see that there are medical devices, there is medical devices regulation. So for example, if you are developing a product that you want to register as a medical device, you need to undergo conformity assessment according to this regulation. A very, very tough process to do. But due to the fact that medical devices regulation almost in no way focus on the risks of the AI systems, you need to also undergo the conformity assessment according to AI Act. I will see like how the process will look like. So this might be pretty confusing, but in practice it shouldn't be. The second source, if you do not find your AI system under the scope of this legislation in the Annex 2, the second source for you is the Annex 3. And Annex 3 has listed certain areas with certain applications that should be considered high risk. For example, you can find their biometric identification. So what is not banned, it's allowed, but it's high risk, so it needs to go undergo conformity assessment. Under biometric identification, you can, for example, also find some emotional recognition systems and so on. So the list is pretty longer. You can find the area of management and operation of critical infrastructure, including operation of AI systems that are used for energy consumption measurement or water supply management and so on, so in the critical infrastructure of the state. You can also find the area of education and vocational training. So for example, if you use it at universities, some automated systems that are used for selection of students or so on, that's high risk. Employment, a huge area. For example, if you use AI systems for filtering CVs that the candidate sent you, again, it would be probably high risk. Great area or big area is access and enjoyment of essential private services and public services and benefits. It might sound mysterious, but if you look at the more details there, you will probably find there assessing of creditworthiness of clients. So for example, this is very relevant to banking or insurance industry. And there is also the area of law enforcement and administration of justice and democratic processes. So this is just to give you an overview of how you can find out if you have a high-risk AI system. And so what you should know if you find out that you have a high-risk AI system or is it being developed? Well, like I said, it needs to undergo the conformity assessment and comply with the requirements foreseen by AI Act. The crucial thing to say is that as a firm, you are basically, or as a developer, you are accountable for that. So with certain exceptions, you as a firm will do this part. You have to do the conformity assessment. Only cases of biometrics and emotional recognition needs to involve some state body here that will be created in the future or will be assigned the role in the future. But apart from that, this is the accountability and liability of the company. After you do the conformity assessment, you will register the high-risk AI system in the EU database. And you can put your CE, so that's something that you, for example, know from the laptops or mobile phones or washing machines. It's a very similar process, and you can place the system on the market. It means that it can be advertised, it can be sold, and it can be used. But it doesn't end here. The AI Act also foresees that there should be some post-market monitoring. So as a developer or as a provider, you should be able to monitor how the system is behaving and to tackle some issues if something comes up. The interesting part is like, what is that conformity assessment, or what are parts of it? And well, that depends, because like the true conformity assessment according to AI Act is focused on the providers of AI systems. So organizations that are actually developing some systems or models. And when you find yourself there and you are developing the high-risk AI system, that means that you need to fulfill these key requirements. And these key requirements are resembling the key requirements according to the ethical guidelines on trustworthy AI I mentioned in the beginning of my presentation. There are provisions related to the data quality and governance. So for example, you need to document the sources of data you are using for training models, and you need to be transparent about it. You need to, for example, design processes related to data in a way that you are able to tackle biases and so on. You have requirements related to the transparency, mainly in the form of technical documentation and how your AI system is going to work. You have, of course, provisions related to the accuracy, robustness, and cybersecurity, meaning that you should use as accurate data as possible and as representative data as possible. So you can, for example, avoid those biases. There are requirements related to human oversight and record keeping. I will get back to the human oversight in a moment because it's a really big topic. But this is not the end. Maybe in the original proposal of the European Commission, this was the end, this was it. But in the later stages of the legislation process, well, also the EU found out that, well, but providers are only part of the AI chain, right? Because we have many players involved there. So they introduced also some obligations for the deployers, meaning bodies using this system under their authorities. And they have quite different requirement there. For example, they have to conduct fundamental rights impact assessments, but this is only applicable if the AI system is going to be used in the public sector or for public bodies. So this is not the absolute requirement for everyone, but only for certain subjects. They have to be also compliant with the provider's instructions. So if the provider is saying that you should use the high-risk AI system in some way, you should comply with it. Otherwise, you bear liability. They should also kind of ensure that there is human oversight. And if they fine-tune the model, so for example, if they train the model with some additional data, deployers would be liable that these data should be relevant and representative. So something very similar that is also here. And there are also some monitoring and notification obligations, for example, in case of when data breach or some incident will happen. So the AI Act doesn't cover only providers, but also deployers. And of course, such requirements needs oversight, although you can do the conformity assessment basically by yourself in your firm or with some help of the third party. It also requires the oversight on the national and on the EU level. Like it was said in the beginning of the presentation, today was created the AI office. The office will be also, for example, tasked with the oversight of the general AI models. So specifically, they will not be oversight at national level. Apart from the AI office, there will be created also AI board with a representative of every EU member state, and there will be created technical and very helpful scientific bodies in the form of advisory forum and scientific panels. And interesting that actually these two bodies will also be able to help national competent authorities that will be established in every EU member state. And it has to be said that Slovakia has a really good word and was really active in developing how actually the AI oversight and AI governance look like. So it's also maybe the success of our EU cyber diplomacy, how it looks like, and it needs to be said that we have a really strong board in that. Now to the more maybe specific topics. Like I said, the AI Act also regulates general purpose AI models or formerly in the Act known as the foundation models. This is very specific because they do not have to undergo the conformity assessment, but they have some own requirements and obligations. The Act differs between general purpose AI models and general purpose AI models bearing systemic risks. In general, every general purpose AI model needs to conform to some specific transparency obligations that are related especially to documenting the data that it was trained on. So as a provider or deployer, you need to be really transparent in how you train or model and what data did you use. And this is also very important from the point of respecting copyright policies, because there has been some cases where authors kind of challenged these general purpose AI models from the point of copyright, because they said, hey, but you used my works to train your model and you did not have my consent on that or did not have my authorization. So this is something that AI Act is trying to somehow complement, but luckily in the EU we have still the great opt-out model, so it's not that bad as it may be looked. The general purpose models that bear systemic risks will have some additional obligation. So for example, they will need to undergo continual assessment and continual mitigation of risks. There are specific requirements related to the cybersecurity for them. When I read the documents from the EU, they expect that there not will be that much general purpose AI models with systemic risk because of the threshold they set. It's like, in technical terms, I've heard it's really high, so it may be fulfilled by GPT models and maybe some another two, and we are done. So don't worry, I don't think in Slovakia we will have like a general purpose AI model with systemic risks, but a general requirement will be still applicable if you provide or develop one. And when I talked about the ethical side of the AI Act in the beginning, like it started in 2019 with ethical guidelines for trustworthy AI, and this is something that it's really interesting because it's really visible in the AI Act that the AI Act is actually took some of these requirements and make them legal obligations. And this phenomenon is called ratification of ICT governance in literature, and basically means that some kind of ethical consideration or ethics-based assessments are slowly finding its way into the hard laws or into the regulation. And this is something we see a lot in the recent EU digital regulations. So the trustworthy AI, according to the ethics guidelines, has 7 key principles: human agency, technical robustness, privacy, transparency, diversity, societal and environmental being, and accountability. And when you look at this, how these are translated into the AI Act, you can see like the connections. For example, you have requirements on human agency and oversight from the trustworthiness or ethical sign point of view, and you can find directly in the Article 14 what are requirements from that will be required from the legislation. The same applies for robustness, for privacy, and for transparency. The other ones that I haven't like highlighted or connected to the specific dot, it doesn't mean that they are not there. They are there a little bit maybe more hidden, but they're also these requirements for trustworthy AI, they're also part of the other pieces of legislation that I mentioned at the beginning of my presentation. So for example, you will not find a specific article on environmental well-being or sustainability in the AI Act, although it used to be in the proposals from the European Parliament, but this will be part of the due diligence directive that is EU preparing. So it's just gonna appear in some other act. And to maybe give you the flavor of how this is translated, so for example, if you look at the ethical guidelines on trustworthy AI, and specifically if you look on the derivative work that is assessment list, that is basically making these guidelines to work in questions, so it is maybe more easily used by companies, you can see that, for example, if the one of the questions that you should ask is, could the AI system affect human autonomy by generating over-reliance by end users? This is something that is directly reflected in the AI Act, when AI Act requires that if human is overseeing high-risk AI system, it shall remain aware of the automation bias. So basically, the answer for this question is legal obligation. And the same is applicable here. Did you put in place any procedure to avoid the system inadvertently affect human autonomy? Well, according to Article 14 of the AI Act, you should design high-risk AI system in a way that it includes human-machine interface tool. So it means that there is always human in the loop and that there is human oversight. And this is just one of the many examples that you can find there, how these principles are translated there. And I'm talking about principles of trustworthy AI and their translation to the AI Act because this is actually something that, at least at the first step, we are also doing in Kinit. Like I said, what we already been doing with our industry partners, we'll be doing ethics-based assessments. And it's basically an iterative process when we are trying to identify ethical and societal risks of the specific AI system or process where AI is involved or specific product. It has some phases, but as you can see, at the heart of this assessment is actually using the assessment list, so the list that is based on the ethical guidelines for trustworthy AI. But we do not end there. We do not only ask our partners and clients the questions, we're also trying to, when we identify ethical and societal risks, to provide them with some risks and countermeasures, what they can actually do to maybe mitigate it. And while we are doing this, we are also trying to point out the clients on the legal side of the view. So for example, if we talk about human oversight from the ethical point of view, we also point them out to the Article 14 and saying, well, but this will be also part of the legal obligation, so you should really take care of it. And this is true for basically every step of this ethics-based assessment in practice. So maybe to conclude, legal compliance is absolutely essential and something that you must do. But AI systems usually bear also some broader ethical and societal risks. So you should also bear in mind that. Thank you very much. My time is up.
Thank you. Thank you, Matusz, for the interview, for the in-depth overview of the legislation. And I have to say, I actually have seen this presentation several times in the past 2 years, and it always changes like really significantly with this content. So you can imagine how it was evolving in the EU as well. And we will talk about all the changes and the outcomes now with Juraj Čorba from the Ministry of Informatization, because he was right in the middle of the process. So thank you, Juraj, for coming and welcome.
Thank you very much.
Hi. And we'll sit over here.
Nope, pardon.
And as I mentioned at the beginning, don't forget that there's an opportunity to put questions in Slido, and we will get to them both with Matusz and Juraj after we finish our short interview. So let's start with what we've seen, and basically what I wanted to ask the first, that, you know, Better AI Meetup, it was started with the idea that AI research and application can be developed anywhere, and therefore Slovakia or Central Europe can also be one of the strong AI countries. What was the position of Slovakia in the discussion of the AI Act? As Matusz mentioned, we had like very strong cyber diplomacy, as he put it, so that was really nice. What was Slovak position in the AI Act?
Yes, thank you very much. We indeed appreciate the words that were mentioned. Look, the whole process started in 2021, and we all know how quickly the field evolves. And yeah, I mean, it was already recognized in 2021 that this is a field that probably requires a certain extent of caution. Mm-hmm. There were many discussions on whether we should regulate and whether we should use binding tools or soft tools. Now, the European Commission made a decision back in 2021 And in principle, Slovakia has been supportive of the idea to try to grasp and help the businesses address risks and impacts on one hand, and at the same time protect society, including businesses, on the other hand. So, in general, supportive, yet, of course, from the very beginning, we had very substantive issues that were raised during the negotiations. First, at the Council of the Ministers, where the individual member states have their say. Mm-hmm. And then, of course, also in the final phase of the negotiations that take place between the Council of Ministers, the European Parliament, with the participation of the European Commission. So this was the start. Now, if you ask me about the result, yes, we managed to improve some of the parts of the AI Act. We did not succeed with some major changes that we were trying to introduce in how to actually think about the technology or the techniques that we call AI. Yet, I mean, this was a huge process. The negotiations, the final negotiations between the European Parliament and the Council of the Ministers were among the longest ones in the history of the EU. Mm-hmm. People sitting there for nights and days, very difficult. So you need to see that this is a very broad process where various interests needed to be balanced, and the text we have is the common denominator we were able to reach.
Oh yeah, I understand. I was following AI Act through like weekly newsletters, and every week there was like something completely different in each new newsletter. So that was, I have to say, it was quite confusing. At the same time, I could imagine that, you know, every week had to take like very long negotiations because, you know, it was changing so quickly. So I mean, we have researchers and businesses there, so maybe the main question everybody wants to know, how should the researchers and businesses in the AI prepare for the incoming legislation? Is it in any way comparable to, for example, GDPR, DSA, or other similar regulation that we had experienced in recent years?
I see. I think it is very important to distinguish between researchers and businesses, as you call them. Now, research as such, if you look at the AI Act when it comes out into the public, research is basically not covered under the AI Act, maybe with some caveats. I will not go into the details. The question is where research and development starts and ends, and when you have something that you provide on the market. We know that we have beta versions of the products, as we call them, or software services, as they are maybe more properly called. So yeah, there is a line to be made between like where the R&D starts and ends, and where the marketing, when putting on the market or into operation, starts. This may be difficult, especially for software and AI. So research in principle is out there for the researchers. What could be interesting is a parallel negotiation that is ongoing at the Council of Europe, which is an international organization different from the EU, where we have a much larger pool of participating parties, where we are negotiating the first ever international binding treaty on AI. Now there we are still discussing to what extent this treaty, distinct from the AI Act, will cover or not cover R&D. So that's for the researchers. For the businesses, what will change was the question, right? And how to prepare. I mean, depends on how you see it. Basically, you have a lot of new requirements, as was very well presented by Matúš Mesarčík. Many of these requirements might be new to the businesses, some of them possibly not, will be new ones. Then it is very important also to bear in mind that this is not only about AI Act. You have mentioned GDPR, we have the Digital Markets Act, we have the Digital Services Act, which impacts on AI, and there are many other tens of binding EU legal regulations that will have impact on AI. You saw the chart. So when it comes to the AI Act, it is also important to understand that it is based on what we know as standardization processes. In other words, the European standardization bodies, CENELEC, and the global ones, such as ISO, they now work on certain technical standards, or norms, as we call them in Slovakia, which should translate those requirements in the AI Act into concrete, even more detailed requirements. Now, when you comply with, or when you need to comply with the AI Act, you will be able to choose whether you follow the standard that was approved and became a harmonized standard for the EU, or whether you choose your own path and you take the burden of proof onto yourself. But you don't need to choose the standard, but you can try to prove that you have complied with the requirements in a different way, but you still need to prove it, right, as a business. Now, even if you comply with these standards, and even if you comply with the AI Act, you need to bear in mind that we have other branches of the government, not just the legislation and the legislature. So what we have experienced now in December is that as the final wording of the AI Act was negotiated between the Council of the Ministers and the European Parliament, surprise, surprise, the Court of Justice of the EU rendered two extremely significant judgments that do not relate actually to the AI Act. How could they? The AI Act was not approved yet. But relate to Article 22 of GDPR, which relates to the so-called automated decision-making. And there, if you look at the judgments of the court said many things. But one of the messages that the judges are presumably trying to communicate to all of us in the EU is that when it comes to the impact on fundamental rights and the possible harms caused by automated decision-making systems, including AI, the judges keep their last word. You can do your best to comply with the standards, you can do your best to comply with the AI Act, but when it comes to the details, it seems that the judges will want to have the final word, and all business strategies, all compliance units most likely need to take this signal very seriously.
Okay. So as Mateusz mentioned as well, you know, it's a part of the complex system, and so we will need to watch out for more sentences. Hopefully not in our case, but we will see.
You mean judgments?
Yeah, judgments. Yeah. Yes. How about transposing to the local legislation? What shall we expect in Slovakia? What do you think? Because you know it's become a sort of habit that we get like very special regulations on top of European regulations when transposing to local. So how much is local legislation actually important, and how much is it imported like directly from the AI Act?
I see. You are alluding to the so-called gold plating.
Yeah.
Basically, I guess everyone in the room knows that this is to become a regulation. A regulation, which is the AI Act here, is directly applicable. So when it comes to like transposition of concrete rights or duties or processes, there's no need, because this will apply directly from the time of effectiveness of the regulation, which is graduated, yet many of the important parts of the regulation will come into effectiveness pretty soon. Some of them most likely already this year.
Yeah, 6 months.
Right. So as regards the substance, we more or less can rely on the wording of the AI Act as such, but we need to create institutional structures, basically new types of public institutions that will be tasked with public oversight that will be tasked with running the experimental environments, such as regulatory sandbox. And of course, all these institutions that will be put in place need to be so knowledgeable and so ready that the businesses here in Slovakia or those businesses coming from the outside will not be facing unexpected hurdles or confusion. So there is an important role for the state here to make sure that we are ready on time and that we apply the regulation as expected. Now, my last final sentence on this, when it comes to the transposition, as you called it, the capacities in Slovakia are limited. And they are not limited only in Slovakia, but in the whole EU. I mean, you can count maybe on a simple calculator by hand those people that really understand the general purpose AI models and are experienced in that field. This is just one example, and there are many other types of AI. So basically, here in Slovakia, it is clear that we need to look for synergies because we have many other tasks under the other AI regulations, I mean EU regulations, sorry. Namely in the field of digital platforms, data protection, data management, Internet of Things, digital finance, and so on and so on. Now, can we build separate structures in Slovakia for all these different tasks? Will these people understand what they are put in charge of if they do not follow also the other digital aspects of the products and services being put on market? Big question there. This is something that the state will be addressing in the upcoming months.
Talking about capacities, I'm assuming that the people who would be able actually do that are actually either here or watching us. So take care. There will be no new job opportunities soon. So don't forget to check, the government websites. Okay, so when talking about AI Act, will the AI Act actually make maybe not research, but AI-based business more restrictive for EU companies? And what will be the benefits and disadvantages, of course, for EU-based companies when coming to the AI Act?
I see. So you are now asking about the difference between the EU and the rest of the world?
Yeah, the rest of the world. Yeah.
Do we remain?
Maybe if it's, let's say, if it's possible to run away, from the EU regulation, let's call it like that.
Yes. This was a big discussion, of course. Will we remain competitive with the rest of the world? The rest of the world seems to be not necessarily going in the same direction. There are some examples, of course. I have already mentioned the works on the binding international treaty that will presumably include also non-Europeans. On the other hand, when it comes to hard regulation of AI, there are just few examples of specific legislation being adopted in relation to AI, such as in China, for instance, in relation to generative AI. Maybe in some other parts of the world as well, but Canada has its own thinking on this. But it seems that a lot of countries in the OECD or even wider global arena, they want to learn first and then go for the binding legislation. So yes, we need to mitigate the risks here. We need to make sure that we complement the binding regulation with such a professional environment, predictable environment, in which investments can still flow. We know that we are lagging behind. We have a huge investment gap in the EU, in the digital and in AI specifically, in comparison to some of the other parts of the world. And this is not only about public finance, of course. This is also about private investments like venture capital and so on. We are very conservative in the EU. So we need to make sure that to the extent possible, we remain flexible and all those companies that will try to enter the EU market from the outside, they will need to follow our rules. That's the logic of the AI Act.
Okay. But do you think that maybe other big countries, I mean, those that maybe are more heavily invested in the AI, will also try and adopt some sort of, let's say, harder legislation? You can see some, in some parts of the US they already do. So do you think it will be like a more global phenomenon after AI Act comes into force?
This question is basically the question whether we can still achieve the Brussels effect as we did with GDPR.
Yeah, sort of.
First of all, I'm not sure we have achieved a full Brussels effect with the GDPR.
Okay.
Now, with the AI, it will be even more difficult. Of course, there are many pending legislative proposals, even in countries such as the US or China, which is now, to the extent I'm familiar with the developments in China, pondering its own general legislation on AI, somewhat similar to what the EU did. We will see what the result will be. Yet, I mean, we cannot really expect that the rest of the world will just take what we have done. And I'm not sure this applies for the states. They have very different views on AI governance. And when it comes to the companies, of course, they may tend to extend our standards, our norms to their practice beyond the EU, which was, let's say, the case of GDPR. But this is also to be seen. In this particular case, I do not expect too much cross-fertilization beyond the EU market, but we will see.
Okay, and my last question before we leave the option to ask to our watchers and listeners. The AI Act has changed quite a lot. We already mentioned that. How do you expect that it will develop over the coming years? Because it will be important as well. I mean, it reacted over the time to generative AI, to large language models, which were not considered at the time, to all the, emotions and everything. So how do you expect it will be able to actually keep the pace with the, really fast developing AI world?
This is one of the biggest questions. Throughout the whole negotiation, we were the ones pushing heavily for maximum flexibility. Because once you write something into the law, you certainly know that the EU legislative processes are very demanding, time-wise, capacity-wise, etc., etc. So, yeah, I mean, there are some review mechanisms already in the AI Act. It is foreseen that the Commission will review the Act, I think now within 2 years from the date of effectiveness, and it should report on this. I'm not sure this is fast enough, but we'll see. Now also there is certain flexibility for the EU Commission, which is tasked with supplementing the AI Act with the so-called implementing acts and delegated acts, where the AI office, ergo the European Commission, will fine-tune some of the details, and then they can change them on the go, hopefully, reacting to the developments on the market. But if it is about the legislation, things will become extremely difficult. And just to give you one concrete practical example, we've started checking the software in the EU with the medical devices. We have this medical device regulation that was adopted several years ago. Then we realized that we are not ready for it, so the effectiveness was postponed. And now we have a situation several years after the effectiveness of the medical device regulation that the providers, the deployers, the hospitals, the doctors, the patients are unhappy because the procedures and the admin related to the checks on software, and that wasn't even yet AI, simply are too burdensome. And we are facing a situation that whereas the rest of the world is possibly pacing forward, some of the cutting-edge solutions are not available on the EU market. And this is an experience that we already have. And it took us quite a long time actually to respond to this. So let's hope that with the AI Act we will be more flexible.
Yeah. Our biggest fans surely remember that we actually talked about this the last time on Better AI when we talked about AI in medicine. So yeah, we heard about these particular things. Thank you so far, Juraj. Please stay with us because I want to invite Matúš and we will take questions. I'm hearing there's quite a lot of them. So so let's start and we will try to go through most of it. Okay, yeah. So, Mr. Čorba, do you know anyone in Slovakia who is actually working on generative AI cybersecurity, specifically with ChatGPT?
In Slovakia?
In Slovakia.
Personally, not.
Yeah. Me neither, actually. Yes. Andy, if I may ask you for further questions. Yeah. Does scoring of clients in order to select the suitable group for marketing communication count as social scoring?
Would you like to?
Yes. This is
That depends on the interpretation, right?
yeah. From my experience, it doesn't have to really involve AI, but it also depends on how it's defined in the AI Act. Because there's actually quite a lot of technology that's not AI based. For example, if I talk from just our field, like fingerprint matching is not AI based at all, but you know it still counts under biometric systems. So you know this is I'm really curious about how this will be solved, even if it's, for example, not running on AI or machine learning or anything.
This is definitely not going to be banned because the ban for social scoring is for example, for some very specific context when you can use the data or the system. So, and I don't think this is it.
It will come down to words. We are still in the process of finalizing the linguistic aspects of the AI Act. I respectfully will not answer the question now.
Yeah. I just want to remind all that we are not here as a legal counsel, so yeah, please take everything with a pinch of salt. Okay, so we already had the first questions, but I will ask the next one. Will the AI Act conformity assessment be the responsibility of a state institution, as is the case with pharmaceuticals? Or it will be a responsibility of the private company itself. So,
as was mentioned by Matúš already in the presentation, basically the bulk of the AI Act rests on self-assessments by the companies. Only in certain particular use cases you will need to involve public authorities. Now, of course, the self-assessment may be difficult as such. So even in those cases where you self-assess, you may still need the help. And we can now discuss how is then the regulatory sandbox important for you so that you can find the possible guidance with the help of the state. We may discuss to what extent all the guidelines, implementing acts, delegated acts to be issued by the European Commission will be helpful or not. But you need to bear in mind that even if you self-assess, you yourself remain responsible. And maybe last sentence on this, last idea that came to my mind, it will be very difficult for small players on the market to do this by themselves. Matúš already alluded to the possibility of either seeking the help from the public authorities or seeking the help of independent third parties. But then, of course, these assurance or auditing services will also need to be checked. And we will see how the market evolves.
Yeah, and also let's get back to the European Court of Justice, which wants the last word in this. So, yes. So we have a third part of the question, and it was about the changing threat landscape, new enterprise risks introduced by generative AI and ChatGPT. This is probably a question, if I may rephrase that. If you use generative AI and ChatGPT, how will it actually affect your business? For example, I don't know, if you're a media company, you're using generated, picture generated by AI, or you use chatbots that use ChatGPT. How will AI Act affect this part of your business?
Well, I will start. Well, this is the question that we get a lot because it's really up to date. And the thing is that this is something that is already regulated by the EU law, because you have a copyright regulation, you have a specific exception for data mining, and actually a regime that you can use for training the models. The AI Act, the only thing, but correct me if I'm wrong, what it's doing is that you should have the copyright policies in place and be aware of the of such things that are there and that you comply with.
Okay. Let's move to the next question. Can you explain the role of fundamental rights impact assessment as a tool for assessing the societal impact of AI systems and how it should work?
Yeah, well, the good thing is that if I'm not wrong, the Commission will also adopt the delegated regulation on that with a template or sort of the template, if I'm not mistaken. So it's not going to be that much burden maybe on the deployers, but basically the role of the fundamental rights impact assessment is that you identified relevant rights and freedoms that might be somehow endangered by your AI systems. It's basically a theoretical exercise, so if I can say so. And when you do this, then you should some kind of label the risk. So if the risk is very high, medium, on something that you know from the cybersecurity regulation or from other types of regulation. And if you do so, you will see that some rights may be endangered by your AI systems, maybe in a more severe way than the others. So when there is like a high risk or very high risk, you need to adopt some mitigation measures. So this is basically the role of the fundamental rights impact assessment. I mean, you have a lot of methodologies how you can do this. You can also find them online or in the literature. But like I said, I hope that the Commission will provide us with maybe more guidance on that.
Yeah.
On this, you may know that this was a request from the European Parliament to include these fundamental rights impact assessments. This did not come from the member states, from the governments. Now, you know that these impact assessments are in place for a long time for GDPR. They are already in place or will be in place for many other aspects. You may heard about the due diligence directive and other fields of business activity where you are either already expected to undergo impact assessment analysis or you will be soon expected to do so. Now, of course, the key issue is will this turn into a box-ticking exercise? If it turns into a box-ticking exercise, the value decreases. But bearing in mind what we have mentioned about the relevance of the final court's review of what you're doing, specifically when it comes to protection of rights, it will have clearly a value there so that you can, with the help of people who are specialized in this field, not necessarily only lawyers, will be able to help you to navigate the risks that you identify and the mitigating measures that you may take to eliminate the possibility that at the very end of the day, your system that you are either providing or you are deploying has such great impacts that you will then just be very unhappy that you underestimated the need for such analysis.
Yep. Okay, let's move on to another one. What might be the alternative to the product liability approach? How are market surveillance authorities going to deal with the puzzle? Thank you.
Now, I'm not sure what we are referring to here because product liability falls under a different legislative initiative.
Yep.
There is a product liability directive that is currently being negotiated and it's, according to the information available to me, at the very end of the negotiation process. That product liability directive also touches upon aspects of AI. Not to be too happy that we are finished with the liability there. There is another proposal for a directive which specifically addresses AI liability.
Okay.
These two directives fall under the purview in Slovakia under the Ministry of Economy, in the former case, and in the latter case under the purview of Ministry of Justice. We are helping them, of course, but liability rules need to be really distinguished. This is not what the AI Act is about, okay? The AI Act stipulates certain rules, requirements, duties, processes, but the liability aspect is a different thing and will be legislated in a separate pieces of legislation currently pending. And if the distinguished madam or gentleman who has submitted this question, as it is anonymous, meant the product safety approach, which has been the blueprint for the AI Act. Now, yes, indeed, from the very beginning, since 2021, Slovakia was the first one, already in December 21, to raise the issue that we are not sure that the product safety approach, with all these market surveillance authorities that are being mentioned in the question, whether actually this is the right approach, because product safety approach was basically designed in the 80s, in the last century, and it is basically designed for mass production, mass industrial production of products that are more or less stable, physical,
Yeah.
when they leave the production process, whereas with software, we are in a completely different environment. So from the very beginning, since 2021, we tried to present the respective negotiating parties with some other alternatives to the product safety framework. I mean, the product safety can be useful for tangible products. Matuš has shown them in the graph. Some of them are really tangible, like toys, vehicles, maybe even the medical devices, etc., etc. But many things just run on software. You don't see them, you can't touch them. Social scoring, where would you look for it? So I have to say that we did not succeed. But, although we have raised this issue since 2021, we felt that there are better inspirations for the legislation that can be taken as an inspiration, such as the financial sector, which is specifically designed for fast oversight of extremely complex and dynamic systems, which arguably software and AI is, right? So, yes, I mean, there are alternatives to the product safety framework. They were accepted partly only in respect of the general purpose models and systems. They do not quite fall into the logic of product safety framework. And we will see whether we will need to reconsider this or whether the product safety framework will work. We will do our best, of course, with the market surveillance authorities that will be put in charge in Slovakia to work on this as best as possible with the European Commission.
Mm-hmm. Yes. Is this an attachment of GDPR, and when will it have teeth? We have a question here, so that's really nice.
Yeah, okay, so I will leave the teeth part to Juraj as a state or representative of the state. I will answer the first part. Well, yes and no. No, because GDPR is more about regulating the processing of personal data, so it's more about processes and it more emphasizes the rights of the data subjects and how it should work. The AI Act is based on a philosophy of product regulation, so it regulates product and what it should comply with when it enters the market. So I see the difference here that in the scope, maybe it's not so visible on the first sight, but there's definitely difference in the scope. And why it might be considered as an attachment, or why I see the positive point of it is that GDPR actually, and not only GDPR, but also the predecessor of the GDPR being the directive on the data protection, regulate the automated decision-making process. And it's been there since 1995, so pretty long. But according actually to the decisions that Juraj made, that was made in the December, it makes the Article 22 of the GDPR dealing with automated decision process making like very narrow. And so in that sense, it's quite toothless. For example, this article and the requirements do not apply to recommender systems on the social media, or at least non-data protection authority said that it applies because there is like great room of maneuver how you can interpret it, and CGU actually kind of circumvented, but like Juraj said, it's the instance with the last word. But that also the same conclusion applies with the guidelines for that article. So yes and no, it's not that. It's based on how you look at it.
Yeah, and then there's the other part of a question, when will it have teeth? I would say like very soon from what I've seen, but you may have other answer.
Well, it's a binding legislation, so it should have teeth. The question is, of course, how good will we be in applying all the rules, and even more importantly, applying those rules equally to everyone on the market, so that everyone on the market and the affected persons, like citizens, have a sense that there is a level playing field, that this is not just about limited capacities of the public authorities which pick and choose individual cases where they just happen to chase one or other company, but that it's actually universally applied book of rules, so that the conditions are fair for everyone. I mean, this is the big challenge there. And when it comes to the GDPR, I would just briefly maybe, if I may disagree with what Matúš has mentioned regarding the scope of Article 22 on automated decision-making systems. Yes, indeed, in some aspects it can be read as narrow now in light of the Court of Justice rulings. Yet at the same time, if you look at the impacts now of the Article 22 on your work with automated decision-making systems, you will learn that even if you outsource the system to a third party, for instance, like an insurance company or a bank, hiring a third party to assess the creditworthiness, and even if that input is then still being assessed in the bank, when it comes from the third party, you still fall under the GDPR regulation. So GDPR, the AI Act, the Digital Markets Act, the Digital Services Act, all the acts that you have seen on the screen will need to go like this. They will need to really fit together. And this is a major, major challenge for everyone in the public sector, for everyone in the compliance departments. And we now need to make sure that we do as best as we can.
Yeah, and talking about regulation, which public body will be the Slovak National Authority regarding the AI Act? And I think this is also still needs to be like properly named and solved, right?
Yes, this is more a question to my bosses, but the fact is that Slovakia was the first one in the EU to actually ask for help on this. Already in year 2021, we have asked the European Commission for what is called a technical assistance or technical support instrument, where we have requested that the Commission helps us to identify what is the best possible institutional design, so that we can excel. Because if we create a good institutional design here in Slovakia for all these tasks, including AI, including digital platforms, including data, including IoT, etc., then we can actually stand out from the crowd, right? The services and providers may enter the EU market via Slovakia because they will find professionals here who can understand what is at stake. Now, this technical assistance was finished a few weeks ago. The Commission has chosen a private advisor for us. Now, we will be assessing the results of this. I think one of the first steps will be taken in 10 days. Oh, no, 10 days, tomorrow. Tomorrow, at the Council of the Government for the Digitalization, which is a body, advisory body to the government. And let's see how Slovakia manages, but we need to avoid what has happened to us with the drones. The drones, you know how important they are, by the way, these days. We are the last country in the whole EU that has not implemented or does not apply the EU legislation, which was adopted years ago. And even the national auditing body, Najvyšší kontrolný úrad, came to a finding recently that actually this is lagging for reasons that are not quite clear. And there is a responsibility on the government, there is responsibility on the parliament, and now who is responsible? So these are issues that really need to cut across silos. And you know how challenging that is within the government, not only within companies. So in order to be successful, we need to learn from the case of the drones. We need to understand why we did not manage on time, and carefully assess what can be done so that the government and independent regulators work together to make sure that we are ready.
Okay, thank you. I'm certainly glad to hear that we waste no time in implementing this. So, you know, today we have EU AI Office. Tomorrow we will actually be talking about how to implement it in Slovakia. So that's great. What will be the role actually of EU AI Office and the advisory bodies, and how will it help companies to comply with AI Act? And this is something that interests us as well.
Yeah, I can start. Well, the EU AI Office was introduced only in the recent phases of the legislative process. And well, I see the main task of the AI Office in the oversight over the general purpose AI models. So it's exclusively tasked to this office. It's like overseeing of very large online platforms by Commission according to Digital Services Act. And as far as I understand, but correct me if I'm wrong, these advisory bodies should be composed of technical, legal, ethical experts that should also be should be involved in the drafting of delegated and implemented regulations, and also helping the AI Office to establish some benchmarks, for example, for general purpose AI models. But they also should be some kind of helpful to national competent authorities, but I'm not sure how that will work.
Yes, I can just add that this was one of the issues that Slovakia also pressed heavily on from the very beginning. We just did not believe that if we will put in charge these hundreds or even thousands of national competent authorities, that they would be coordinated enough. So we really wanted to see from the very beginning a strong EU-level support to the national authorities in all the different sectors. Now, to some extent, this went through. As was mentioned by Matuš, there will be some support, central support from the EU level to the national competent authorities, especially via the scientific panel, where there should be experts, I guess primarily in informatics. We'll see. And that will be helping the national authorities on the go, hopefully real time. Just like we monitor the skies with the aviation, I mean, this will be something very similar. Now, when it comes to the other roles of the AI Office, you need to see that the AI Office will play practically exclusive role in the field of general purpose AI models. So this will be the task of the AI Office because finally we came to a conclusion in the EU that to expect all the member states to understand all these general purpose large models and to scatter the capacities all around the EU will probably not work. So this is the exclusive mission of the European Commission's AI office. And we will see how it works. But of course, we hope that this will work as good as possible.
Thank you. We have a few last questions. I will try to join two of them together. So, you know, if you have a currently biometric-based system, for example, face-based access control, or digital client onboarding, or for example, face-based attendance system, what will change for me with AI? Will it be banned? Will it be? Will I have to change it? Will I have to undergo some, you know, some procedure? What's the idea behind it?
It always depends on the use case, but like majority of the biometrics will be considered high risk.
Yeah.
There are, of course, certain exceptions to that. For example, when it's used solely for the verification of the person. By the way, I'm very curious how it got there. But in general, we will have to comply with requirements for transparency, human oversight, and so on. But from what we have already maybe seen with some partners that we have done assessments with, they are pretty good prepared for this. So there are not so many novel things there.
Okay.
So it shouldn't be like something that would be like a nightmare for biometric companies.
Okay.
But also I see like the second question over there on the top about scanning faces of people entering from the street. Well, this is something that we have also been tackling in KINIT, specifically in our research, because we have to delineate what is publicly accessible space, because it's different if you have facial recognition system deployed by law enforcement on the square where there is a protest or where there's a riot or something, and then it's different if you are a private company and you use it for the entrance or for the access for your employees somewhere inside the lobby. Like those are two different situations from also from the point of legislation.
Okay, thank you. I see the question that I wanted to ask as well. I like the idea of Slovakia being the getaway for non-EU companies, or let's say the entry port for the non-EU companies, because of its highly professional attitude to AI. Have you received any feedback on the idea from your higher-ups, such as the Office of the Government?
Let's not hope Slovakia will be the getaway, but rather the gateway.
Yeah.
But I understand the question. This is a gateway. It's just a spelling mistake. Anyway, yes, I mean, this is something that has been in our minds now for months. It all depends how good we do, because the providers all around the world, I mean, many of them are extremely experienced. So I think they will find out within minutes to what extent actually they have a partner on the other side, to what extent the public authorities are ready, or whether we just are moving in a fog. So yes, this would be an extremely attractive goal. Yet, in order to achieve it, we would probably definitely need to go beyond the current priorities in digitalization or digital transformation of Slovakia, and to go into a gear that is much, much, much higher than the one we have been using up until now. So yes, the idea and the opportunity is there. To what extent can we rise to the opportunity? We will receive the answer more or less from the politicians and the higher echelons of the Slovak administration.
Okay, thank you. I see that the last two questions were basically answered during the course of our discussion, so I'll just leave them there. And thank you for your attendance. Thank you for you guys coming here and answering like really a barrage of questions from all points of view. And yeah, let's hope that if we meet here in 1 year, everything will be more crystal clear, and we will have like this head of Slovak/European AI office sitting here and explaining us everything that we need to know. So I think this is the ideal. Thank you again for coming. Thank you thank to all of you for coming as well and for watching us, and see you at 11th Better AI Meetup sometimes in April. Let me just welcome you then again in the name of Kinit, Innovatrix, and Hopero. So thank you very much. Good night.
Thank you very much.